This time we're on record in Westby versus Schaefer, matters before the court for oral argument. Mark Kamatomo will argue on behalf of the appellant. Andrew Chasen will argue on behalf of the appellant, on behalf of the respondent. Jeremiah Kwan will argue, and Melodie McQuade will argue. David Lombardi will appear. Justice Warren Jones is recused, and in his stead, Senior Justice Walters will participate fully in this appeal. Any preliminary matters?
No, Your Honor.
Thank you. You may proceed, sir.
Thank you. May it please the court, counsel, good morning. My name is Mark Kamatomo, and I and Andrew Chasen will be arguing on behalf of the appellants in this case. I've reserved 5 minutes for rebuttal. Mr. Chasen has reserved 10 minutes for his argument. This case, the underlying facts of this case involve medical negligence or medical malpractice. However, the issue before this case is one of discovery that goes beyond the issue of medical malpractice. The specific issues that I intend to argue today, and Mr. Chasen will also address, is that the trial court in this case abused her discretion in terminating discovery 36 days before the discovery cutoff. Part and parcel of that, there is an allegation that there was an agreement by us to do so. I was not part of that discussion. Mr. Chasen will address that, but we'll also be looking at the issue of whether or not there was an abuse of discretion. The facts of this case arise out of the birth of Christian Westby at Mercy Hospital on November 22nd of 2007. The child was born with multiple injuries, specifically multiple fractures of the head, an upper occipital fracture in the back of the head, bilateral clavicular fractures. There was a subarachnoid hemorrhage, a posterior fossa hematoma, and a string of clots in the upper third of the sagittal sinus. We filed a complaint on December 15th of 2009, and the gravamen of the complaint was that there was trauma evidenced by these multiple injuries that constituted negligence in this particular case. Unfortunately, the trial was not set until almost 2.5 years later, specifically June 5th of 2009, primarily due to defense counsel's unavailability. So during that intervening period of time, we conducted the discovery we could, but the first time expert witnesses were disclosed by the defense was February 6th of 2012. Actually, Mr. Hippler, who represented Mercy Hospital at that time, did not disclose his expert witnesses until sometime later. I believe it was the 29th or 21 days later. He asked to have a later disclosure because he had a medical illness of some kind, and we agreed to that. So we have a disclosure of one set of witnesses on February 6th. We have another disclosure on February 27th. Immediately after the disclosure on the 6th by Dr. Schaefer's witnesses, the defense requested mediation in this case, and we agreed to do so. Unfortunately, because they would only agree to one mediator, a female mediator from Canada, we could not set the mediation until March 28th. That occurred, but unfortunately was unsuccessful. 2 days later, on the 30th, I received a letter from defense requesting the deposition of a fact witness, Colleen Hollis, and on that same day we corresponded back and indicated we would make her available, but we would also like the depositions of 8 of the 29 disclosed expert witnesses on the defense side. There was a series of correspondence that essentially went back and forth in disagreements about whether or not that would occur. In the end, because we could not get dates or an agreement to provide dates for the depositions, we went ahead and noticed the depositions for defense counsel's office, and that prompted defense counsel then to file a protective order or a motion for protective order. That led to a series of hearings which really comprised the basis for why we are here. The first hearing occurred on April 11th, and at that time, the court, after hearing oral argument, encouraged the parties to go outside and try to reach an agreement on whether or not there would be discovery involving these expert witnesses. I was not in attendance at that hearing, and I was not part of that discussion, and that is why Mr. Chasen is better suited to address that, as he was there. What I can tell the court is that at that particular hearing, Mr. Kwan argued on behalf of Dr. Schaefer that it was too late for us to depose the expert witnesses, despite the fact that there was still 36 days left in the discovery when the request was made. At page 10 of our brief, and in volume 5, page 864 of the record, I can specifically point to the argument that was made, and his argument was that the request, quote, places Dr. Schaefer in a very difficult, if not impossible, position to arrange the depositions of his expert witnesses, which takes time considering their availability and their work schedule. That's an understandable argument. However, there was no evidence presented to Judge Hoff at that time that would support that claim. There was nothing in the way of a representation that he had actually talked to the expert witnesses, any of them, and that those expert witnesses said they were not available in that time frame. On top of that, if the court will look at the record for that time frame, I made myself available on a number of days. I believe it was April 24th, 25th, the 27th through the 29th, 2 weeks in May, and then followed up with another letter that said I will essentially rearrange my calendar to suit the needs of the expert witnesses in this case to complete the discovery. At the time of the hearing, Judge Hoff continued the hearing and her decision until May 1st to decide whether or not we could reach an agreement of some kind. In the intervening period on April 24th, we brought a motion for a continuance of the trial. It was due to my personal problems. I had a very close aunt that had been unexpectedly diagnosed with stomach cancer. We weren't sure if she was expected to live or not. My family was gathering in Calgary, Alberta, where she resides. Judge Hoff somewhat reluctantly granted the continuance over the objection of defense counsel, and at that time indicated that she had also considered having Mr. Chasen try the case by himself, but then decided not to do that. The trial was continued to 16 months later, till October of 2013. Why that is important is that we now come back on May 1st, which is the actual motion where she decided that discovery would be terminated, and at the time she's making that decision, there's no longer just 36 days left in the discovery, but the trial now has been continued an additional 16 months out. What's also important is that at no time during either of those two hearings was there an express argument or any consideration paid to whether or not the delay, as it was alleged in requesting those witnesses, was due to some dilatory or unreasonable delay on the part of the plaintiffs, nor was there any claim that the defendants would be prejudiced if they were required to bring their expert witnesses forth and allow them to be deposed. The argument advanced by defense counsel primarily was that the disclosures are sufficient, and we don't need to go beyond the disclosures in this case to know what the experts will testify to. Judge Hoff granted the motion for the protective order. She did not articulate any reason into the record. There's no reason, as I understand it, set forth in her order. On September 21st, she heard a plaintiff's motion for reconsideration. For the first time at that hearing, Judge Hoff articulated what we believe was her primary concern. That's set forth in page 6 of our brief, but it's also in the transcript at page 135, lines 14 through 18. As she was going through her rationale, she stated, quote, "This case was filed in December of 2009. The plaintiffs did not depose either defendant Schaefer's experts or defendant Mercy's experts during the year 2010, during the year 2011, or during the year 2012. Upon hearing that, it became apparent to us that she was under the mistaken impression that we had sat back on our laurels for 3 years after defense experts were disclosed and not taken their deposition. We corrected her during that hearing and pointed out that the depositions could not have been taken because they were never disclosed. The first time we learned about them was February 6th, and then on February 29th. She still granted the motion after that and didn't articulate whether or not that was part of a rationale. We can only assume that that might have been part of a rationale, and if so, it was based on faulty reasoning since we could not have taken experts we didn't know anything about. We made one last final...
When Judge Hoff made that statement suggesting her belief that it was dilatory, at that point, it had to be fairly clear to you that what she was thinking, wasn't it?
Correct, and that's why I believe the record will reflect I got up and pointed that out.
Yeah, but you also said that you didn't want her to revisit her ruling at that point. Why not? I'm just curious.
I'm sorry, can you say that again, Justice?
You indicated that you didn't want her to revisit her decision. You just wanted it to be in the record.
Oh, that's a misstatement on my part. We actually brought it up because we felt she should revisit her ruling, that the basis for her ruling was based on faulty or erroneous information. If I've left you with the impression somehow that we didn't want her to change her ruling at that time, that's incorrect. We felt she was wrong.
Well, it was your statement. I'm not asking the court to revisit its motion. I just need to make a record in the event the matter finds its way into an appellate record.
In the transcript itself?
Yes.
I guess the intent, Your Honor, was not that it wasn't important. Our feeling was that she had made an erroneous ruling based perhaps on faulty information, but it wasn't entirely clear to us that that information was in fact information she had relied upon. So that is the rationale for why I made that statement. We come to the November 20th permissive appeal hearing. She denied that as well. I think what's important about that hearing is that for the first time, twice during that hearing, she stated that the reason she had cut off discovery was as an accommodation to the defendants for granting the continuance motion. And again, as I will move on, I'll explain why I believe that was erroneous. Let me get to the law. This is a protective order. And as I understand it, under IRCP 26A, protective orders can be granted for annoyance, embarrassment, oppression, undue burden, or expense. They're reviewed under an abuse of discretion standard. The three factors that this court has laid out is whether or not the trial court correctly perceived the issue as one of discretion, whether or not the trial court acted within the bounds of discretion and consistent with applicable legal principles, and finally, whether the trial court reached the decision through an exercise of reason. The first one we can't argue with. I think trial courts have to have discretion when it comes to the management of discovery. The second one, we believe she acted in error. There is no specific legal authority we're aware of that talks about at what point a court can arbitrarily or with reason terminate discovery. But there are certainly plenty of cases out there that this court has talked about and laid out principles dealing with discovery. Edmonds versus Craner is one of them, and the court in that case talked about the importance of discovery to allow you to adequately prepare. Another is the Radmer versus Ford Motor Company that talked about the importance of discovery to promote candor and fairness in the pretrial process. And there's also the Bailey versus Sanford case, and in that case the court upheld the trial court's decision to not allow a deposition, and they came to that reason because they felt there had been an unreasonable delay and that the opposing party had been prejudiced. And then my understanding is there was a 2-year delay in requesting the deposition. In this particular case, we were provided with literally hundreds of pages of disclosure of what these experts would say. In most of the instances, they were just conclusory statements. For example, at volume 1, page 57, one of the statements was that Dr. Armstrong will opine that the shoulder dystocia was managed by Dr. Schaefer in compliance with the standard of care. And then attached to that are excerpts pulled out of voluminous amounts of medical records, and supposedly, I guess, we're led to believe that that will be support. That tells us nothing. This court's not spoke to that directly, but we cited to U.S. versus Garrett, a federal court case, that said Rule 26 requires a particular and specific demonstration of facts as distinguished from stereotyped and conclusory standards. And this court has often said, if the language of the Idaho rule is the equivalent or comparable to the federal rule, then you can look to the federal counterpart for guidance. I would say that the purpose of discovery, if we're going to rely just on disclosures, you have to have something more than a very broad-based statement. We were entitled to take the deposition of these experts. We are entitled to know what they had to say, which brings us to the last argument, and that is whether or not the court reached this decision through an act of reason. And we would say again, no, it did not. The most important, perhaps, hearing is the first hearing, because that's the basis upon which the arguments were made that she made her decision, and she did not articulate a reason at that particular hearing. Subsequent hearings, she laid out rationale that we were able to point out was faulty rationale. And then at the end one, the permissive appeal hearing, there's no relationship between the grant of continuance and accommodation to the defendants in cutting off the discovery. They were two separate hearings, unrelated, no arguments made that should be the quid pro quo. Our position should be that the trial court, or our position is that the trial court abused her discretion when applying the three factors, and in particular did not adhere to the legal principles of discovery that this court has set down so that we could be adequately prepared at trial. We're asking the court to reverse the judge's protective order and reinstate the discovery so that the depositions could be taken. Lastly, just as to the request for attorney fees, this court granted the appeal. We believe that in granting the appeal, that's a statement that it can't be frivolous. And so we would argue that the fees are not appropriate, and the defendants have cited no law to that respect. Thank you.
Thank you. Sir?
Good morning, Your Honors. I want to take up where Mr. Kamatomo left off and turn to the last two elements of the standard of review. I want to first deal with the fact that the trial court did not act in a manner consistent with the applicable legal principles. The case of Edmonds is a clear directive that vests the trial court with discretion to limit the number of witnesses prior to trial and during discovery. And the purpose of these depositions that we wanted to take were to ferret out the issue of cumulative witnesses and whether they were actually qualified to opine what they were apparently, what was revealed in the disclosures. Rule 16 directs the court to limit the number of witnesses pre-trial, not just during discovery. And Rule 1 says that the rules shall be liberally construed to secure just, speedy, and inexpensive determinations of every action. The purpose of the rules is to prevent unfair surprise and effective cross-examination and rebuttal of witnesses. So the court is supposed to consider the issue and determine fully what expert witnesses should be allowed and allow us to engage in discovery that will help that reasoning. It's interesting to look at page 175 of the transcript because in that the trial court engages in a soliloquy that's almost identical to the one that was condemned in Edmonds. The court says on page 175, bottom line, I cannot conclude at this time that Dr. Schaefer or Mercy Medical has listed an oppressive number of experts. The court is going to have to listen to the evidence as it comes in and decide whether testimony becomes cumulative. I'm going to skip a few sentences. Now I've had to sit and ponder, you know, how these 403 cumulative objections, she's referring to evidence rule 403, unfair prejudice, cumulative objections are going to come down. In the trials that I had as a practitioner and here as a judge, they come in during the course of the trial, and they can only really come in when we know they're cumulative on the record, and it's very difficult for me at this time to make this call. That's almost, it's amazing how similar it is to the reasoning used by the trial court in Edmonds. And Edmonds instructs a trial judge to in fact engage in the discovery process and make that determination pre-trial. So we were presented with a disclosure of witnesses that numbered 29 between the two defendants, and I want to give you a sense of what the disclosure was like. Dr. Schaefer listed 4 OBGYNs, and the opinion for each of those medical specialties was basically identical in substantive content. They all said that Dr. Schaefer complied with the standard of care. Mercy Medical listed 6 OBGYNs to say the same thing, not regarding nurses, but regarding Dr. Schaefer. Then Dr. Schaefer lists 2 experts on causation, saying virtually identical substantive content. Christian's injuries were not from a lack of oxygen. There was no brain damage. He did not have cerebral palsy, and his injuries were not the result of labor and delivery. Mercy Medical listed 5 causation experts who had virtually the identical opinions. We had 3 genetic experts listed by Dr. Schaefer and 5 by Mercy Med, all providing virtually identical substantive narrative and opinions. And finally, we had 6 nursing standard of care experts listed by Mercy Med that said the nurses complied with the standard of care, all virtually in identical language. So as plaintiffs, we're left with the task of trying to ferret out exactly what the opinions are, whether they're qualified to say what they're saying, and the nature of the cumulative testimony. For example, disclosures on their face called into question whether the opinion fell within the expert's area of expertise. Look at our brief on page 24. An OBGYN, for example, is testifying as to the nursing standard of care. An OBGYN. And then on page 13 of our brief, a neonatologist who is he's a newborn doctor, a specialist, specialized pediatrician, is claiming to be familiar with standards and practices of the OBGYN field. Well, he's not even in labor and delivery.
Well, isn't it a fair tactic to list such a large scad of witnesses that you have to guess as to which one's going to really be the...
You know, that used to be, when you and I were young, the common tactic. But Edmonds solved that problem because it's unfair to list 29 people when the whole point of the discovery process is to prevent unfair surprise and allow preparation so that you can be ready for cross-examination and rebuttal. And we were deprived of the opportunity while the window of discovery was still open. And because we weren't dilatory, we did everything we were supposed to at the time we were allowed, and instead of responding to the letter sent by Mr. Kamatomo that we would like depositions, we got a motion for a protective order in response. That's not cooperation. It's not how it's done in Idaho. I've been here for a long time, and so have you, and we know that's not how it's done.
So as I understand it, Mercy had this disclosure date. Somebody called up and said, well, we've got a problem. Can we...
Well, in all fairness, Mr. Hippler had neck surgery. So, of course, we gave him more time. I mean, yeah.
And that's kind of what we do in Idaho, isn't it?
Yeah.
So give a little bit of leeway to a person because we all want to get to the truth of the matter.
And because the whole idea is to cooperate in the discovery process so you can get on with the merits of the case.
Oh, so that's the objective, huh?
Well, I always thought it was. The last element on the standard of review is that the decision has to be based on the exercise of reasoning. And this trial court made material mistakes of fact in reaching its decision to cut off discovery.
How does this late discovery deadline get imposed anyway? I mean, did the parties become involved like it was 2.5 years? The expert disclosure.
Well, we couldn't find a trial date for 2.5 years, and then the common practice is that a judge doesn't order disclosure of experts until 120 to 90 days out. So we didn't have an opportunity to even see a disclosure until February, and the trial was just a few months away in June.
Had there been other mediation requests and/or tries prior to the one requested?
No, and that's understandable since a mediation, you know, timing of a mediation is everything.
Sure.
And you don't want to do it when it's premature, and people want to wait until all experts have been disclosed. It's really not productive otherwise. So there is one thing that I need to address because I was there, and that's the question of what agreement had been worked out on April 11th. A lot of things were discussed off the record, including whether it was advisable for the plaintiffs to go forward and take these depositions. And I'll just be candid with all of you. There was, and I'm going to run out of time, but there, you know, you used to always want to take depositions of experts. That's just the way it was done. But in the last 5 years or so, there's been a shift in the bar, and often people decide not to take depositions to use it for a tactical advantage. They try and hold the expert to what was disclosed in the Rule 26 disclosure and then bring a motion in limine limiting it, and you feel you have a tactical advantage. And I expressed that sort of attitude when we were off the record. But I clearly said, but I'm not the final decision maker in this case. I've got co-counsel, and we brought him on because he knows the medicine and he does med-mal. And so if you will go to page 35 of the transcript, you will see what I put in the record. I said we have agreed to continue the hearing, that I have to contact co-counsel Mr. Kamatomo. Mr. Kwan says on the record, including the issue of whether we'll even take the depositions, and I said, quote unquote, well, all issues are on the table. But you will also see afterwards that the trial court time and again refers to her assumption that it had been all worked out and that we had waived our right to take the depositions, which is truly a mistake of material fact. It was truly a mistake.
How much time did Mr. Chasen go over?
They have 3.5 minutes.
He went over.
26.5.
He's into rebuttal time.
I'm going to allow 3.5 more minutes to the respondents. You're up, and you get extra minutes.
He didn't go over his total, he just went over reserve.
He went over his reserve time.
Right. He's got 3.5 minutes of his reserve time left.
Oh, okay, that's what it was. All right. You don't get any extra time. I know you're succinct, Jerry, but Mr.
I
Kwan,
really don't think there's very much for me to say, frankly. Everything I say is not, in my opinion, a worthwhile augmentation of the issues and points described in my brief on behalf of Dr. Schaefer. And frankly, deep down, it's my feeling that me standing up here for how much time I do have left is a waste of time. But since all of you are so interested in what I have to say, I'm going to say it anyway, including you, Justice Walters, who you heard cases with me before, and so have the others, except Justice Jones. One important thing I want to emphasize is this. There were 2 applications for an interlocutory review filed by the plaintiffs with this court. 2. One involved the ruling of the district judge on the motion for reconsideration. The second was an application for an interlocutory review by this court on her rulings prohibiting the depositions previously entered. That application was denied by this court. The only issue before this court is whether or not, on the petition for rehearing, the motion for reconsideration of the plaintiffs, whether the trial judge committed error in ruling on that motion. There is nothing before this court to be adjudicated on the extent and nature of the expert witness disclosures of any party, even though I think that their criticism of the expert disclosures of my experts for Dr. Schaefer are absolutely perfect. They go on for pages and pages and pages. In fact, one expert, Dr. Erickson, an obstetrician, listed 25 or 30 opinions and the basis for them, which they don't include in their brief. And they erred when they said Dr. Armitage, or Armstrong, excuse me, didn't list the reasons for his opinions, which is also false. I could read this to the court and it would take me 2 hours, but it isn't relevant to this appeal. Nor is the limitation on the number of experts available for trial relevant to this appeal. The case relied upon so strongly, in which this court reversed the trial court, didn't say that you have to, at a pre-trial stage, limit the number of experts. It said that trial court erred when it concluded it couldn't do that. One of the significant features of the appeal, which is limited to the basis for the ruling of the trial judge on the motion for reconsideration, strongly and is associated deeply with the comments of this attorney at the hearing of his motion to vacate the trial, which was heard by telephone April 24 of 2012. The initial hearing on the motion for protective order filed for Dr. Schaefer was conducted April 11, 2012, in which the court entered its order, I'm not going to allow for depositions. At the hearing on May 24, in order to vacate the trial because of the excuse that his aunt had cancer, when the trial was some month and a half later scheduled for trial, Mr. Kamamoto said this to the court.
What page of the transcript are you reading?
That is on page
Is it page 43? It's not being asked for any appropriate delay or to reopen discovery?
page 43. And this is a quote in reference to his motion to vacate the trial. It's not being asked for any inappropriate delay or to reopen discovery. He said that to the judge when she was considering whether to grant or deny his motion to vacate the trial. He agreed not to reopen discovery. And it was said, in order to influence the trial court, to grant the motion to vacate the trial. Now the position he takes is totally repugnant to that representation when the trial got vacated by the judge. He reneged. He also said at that hearing on the telephone on April 24 of 12 that the interests of all the parties had to be balanced. It was the position of Dr. Schaefer, through me, that we wanted to have the trial June 5 of 12. We wanted to have it. We didn't want the trial vacated. And we wanted the trial to go forward with the discovery being frozen. All aspects of the case were frozen by the district judge when she decided to vacate the trial. In due respect for Mr. Kamamoto's alleged inability to conduct the trial a month and a half later. She froze everything because we were going to go to trial and things were going to be the same as they would have had we gone to trial June the 5th. And that is certainly a valid discretionary function of the judge in consideration of Mr. Kamamoto's desire to vacate the trial, and he agreed to a trial the following year. Mr. Kamamoto agreed to the discovery deadlines imposed by the court. Mr. Kamamoto agreed with the deadlines for the disclosure of expert witnesses. He agreed that the interval between the defendant's disclosure of experts and the close of discovery, he agreed to that. It is my position that anything to do with the quality of the expert witness disclosures in this case by the defense, the ruling of the district judge prohibiting the taking of depositions is not an issue to be adjudicated by this court. The only issue is, did the trial court err in its ruling on a motion for reconsideration? The ruling of the district judge prohibiting the depositions still stands. There's no right, in my opinion, of this court to revisit whether that ruling was right or wrong. It's not before this court, and this court's in no position to render an opinion on that issue. It's only on the motion for reconsideration that counts. Counsel's brief distorts many things. After the mediation took place in March, it wasn't until March 30 of 2012 that a letter came from Mr. Kamamoto saying, I want to take depositions. The discovery deadline at that time was May 4 of 2012. Mr. Kamamoto says in his brief that was a span of 36 days. Well, it is if you count weekends and non-working days. If you count working days, it's 25 days. When the disclosure for Dr. Schaefer was made February 6th of 2012, Mr. Kamamoto waited until March 30 of 2012 to ask for the depositions of experts, of Dr. Schaefer's experts. That's a total of 40 working days.
Does that include weekends?
That is only working days. That doesn't include weekends. I'm just counting working days. He waited 40 working days to decide from February 6th, the disclosure of Schaefer, till the time he asked for depositions. He waited 40 working days, and if you throw in weekends, it's about 50 days. He created the problem about untimely action on the part of the plaintiffs to take depositions. And now he squawks, even though he agreed that if the court would bless him with a favorable ruling on his motion to vacate the trial, he wouldn't reopen discovery.
How could the plaintiffs have deposed your experts in 2000?
Pardon, Your Honor?
How could the plaintiffs have deposed your experts in 2010 or 11?
They couldn't have, because they weren't disclosed. But the statement of the judge was only an historical recitation of what had happened in the case up until that time.
Wasn't very relevant, was it?
Pardon?
Wasn't very relevant, was it, if they couldn't have taken the deposition?
Well, I know it wasn't relevant, but she said it. But it didn't mean that they could have taken them. It's just an historical recitation of what had gone on. And of singular importance on that very issue, Your Honor, is this. In her ruling denying the right to depose the experts that occurred before May 1, she didn't rely on that to refuse to allow the depositions to be taken. What she ruled on April 11 of 12, she didn't talk about that and didn't rely upon that when she denied the request to depose the experts. She didn't rely on that. That ruling on April 11 didn't take that into account. And that ruling stands. And it was reaffirmed on May 1, even though she made that statement, but she didn't make it when she denied the motions to depose, the efforts to depose experts on April 11. She didn't make that statement. She just recited historically what had happened. It really strikes me as odd when a party comes before this court. This court is supposed to be advised by the appellant of the good and the bad of their case, not just one-sided view of the case. And that really bothers me. Nowhere in the appellant's briefs, opening brief and reply brief, do they ever say or mention or explain anything about Mr. Kamamoto's statement to the court on his motion to vacate the trial when he said it's not being asked for any inappropriate delay or to reopen discovery. Why didn't they say that in their brief for you to consider? Why? That's not fair. That's not right, and that's an obstruction of justice, in my opinion. I've always harped that in my cases. You have to level with the court. You have to advise the court of the good and the bad. And to date, they've never refuted him having made that statement, which is documented in the trial in the reporter's transcript, or explained why he said it, or if he meant it, or if he was fibbing, or if he was lying to the trial judge. I've had plenty of cases where trial courts, when asked to vacate scheduled trials, have frozen everything the way it existed at the time. Frozen everything. Even if the trial is 5 years in the future, or 2 years, or 6 months, they freeze it because that's the way the case should have gone to trial when it was scheduled before it was vacated. And that's exactly what the trial judge did.
Have any of those cases gone up on appeal?
Not to my knowledge, Your Honor. I'm not aware of any case on that specific issue. I just know that many trial judges have done that. And that seems to be the fairest way to do it when the motion to vacate the trial is opposed, which we did.
You've indicated that you've characterized his request for continuance as an alleged problem with his aunt.
Yes.
Is there anything to indicate that that was a spurious request?
I don't question the veracity of his statement that his aunt had cancer or was sick at the time on April 20th.
Questioning the veracity. Huh? Are you questioning the veracity of the closeness of his relationship with his aunt?
No, I'm not. Here's what I'm questioning. The trial isn't set until June 5. He says April 24, he wants it vacated because of his aunt. Does that mean that he hasn't recovered sufficiently to be able to think and continue the trial? A month and a half later. That's what I question. He told that to the judge in the transcript. Well, I won't be able to think or concentrate, and I can't prepare for the trial. Well, maybe he couldn't prepare for the trial April 24 or May 1, which is only 3 days before the expert disclosure's time had expired. But how about the whole month of May and the first 5 days of June? I question that. I don't question that his aunt was sick and that he was beholden and fond of her at all. It's that I don't think that he would be deprived of the ability to use his mental capacity to try the case a month and a half later. I think the trial judge bent over backwards to honor his request. And one of the things she took into account was his fact he isn't going to reopen discovery. And 2 more points I want to make. The discovery deadline for the disclosure of experts was agreed to long before 2012. The scheduling dates, the close of discovery, the dates for the disclosures of experts was agreed to. The trial date was agreed to. When the judge indicated on April 11 that there would be no depositions, and this has always confused me, the plaintiffs did not ask the court to reschedule the scheduling order, didn't ask the Supreme Court for relief from the deadline to complete discovery, didn't file any motions to extend the discovery deadline. And this was on April 11. Didn't do anything for relief from the order limiting discovery to May 4. Sat and did nothing. They acquiesced in the ruling of the judge on 4/11 that discovery was frozen, there'd be no expert depositions. They acquiesced in it by taking no action to get relief from it. which they could have done, and I don't know what the trial court would have done. Would the trial court have extended the discovery deadline for a period of time to allow for the depositions? But they didn't do anything. For relief from the scheduling order or relief from the timing when they could depose experts, they sat and did nothing. And then they agreed on 4/11 to continue the hearing on whether they could depose experts. And in the record, Mr. Chasen stated he didn't think it was necessary to depose experts. He said that. But it was up to Mr. Kamamoto to make the decision. In fact, by acquiescing in her ruling that there'd be no depositions of April 11 is totally compatible with the statement at the hearing on the motion to vacate the trial by Mr. Kamamoto. His motion is not being asked for any inappropriate delay or to reopen discovery. He said to the court, I agree, we're not going to have any reopening of discovery. And it wasn't until May 1, 3 days before the disclosure deadline, that the decision of the judge was entered, there'd be no depositions. 3 days. And he sat around and did nothing. Just one other thing that isn't relevant. Mr. Chasen mentioned about the switch in deposing experts. And he said 5 years, it's been 15 years for me. I've tried more cases than all the lawyers in this room put together, more medical malpractice cases than all of these guys put together. I seldom have ever deposed an opposing expert, ever, because there are too many disadvantages versus the advantages to be gained for a host of reasons. My win-loss record doing this is identical to my win-loss record when I took depositions. It hasn't changed a bit. It's 99% wins. Of all the cases I've tried, I've won 99% of them with no fault assessed against my doctor client. And I don't take depositions of experts because it's a waste of time. Clients are burdened with the absolute ridiculous expense of paying for the experts. And it ain't even necessary. And in fact, in Oregon, you can't even depose an opposing party's experts in the state of Oregon. But that's immaterial. I don't know why Mr. Chasen even brought it up. Because that's not an issue before this court on the adequacy of our disclosures, or if or not their testimony is needlessly cumulative, which the rule of evidence says. Needlessly cumulative, not just cumulative, needlessly cumulative. That means you can have cumulative opinions of experts. Nothing I've said probably won't make any difference to you. And my brief, the shortest of all the briefs, says everything on the narrow issue of what does a trial judge have to do in ruling on a motion for consideration. We have some decisions from this court, but my thought was when we got this appeal was that maybe this is an opportunity for this court to redefine what a trial judge has to do in ruling on a motion for reconsideration. What are the guidelines or the rules? And only one other thing. All this court can do in its ruling, if unfavorable to my client, is to remand the case to the district judge to revisit and rule on the motion for reconsideration. That's all this court could do if it decided adversely to my client. That's all you folks can do. You can't, as a matter of law, reverse the trial court and say she erred when she ruled there were no depositions. That's not before this court. That's all I think you could do if you disagree with me. Just let the judge decide the motion for reconsideration again and apply the criteria and standards you impose on such a motion. Thanks.
Thank you, sir. Ms. McQuade?
Your Honor, I'm not sure that we still have time left. I'm not sure that it's split now, so if the court would allow a few minutes of argument.
How much time is left? All right, I will give you 3 minutes.
Did I take her time?
I know, it just went by. When you're up there, it just flies.
The answer is yes.
Sorry, I didn't realize I was doing that.
You just owe her some time.
Yeah.
Now we're wasting her time.
No, we're not. She's not yet. Okay.
Mr. Chief Justice, and may it please the court, my name is Melodie McQuade, and I'm appearing today on behalf of Mercy Medical Center. Mercy's argument largely overlaps with Dr. Schaefer's, so I'll try to keep this very brief. This court granted plaintiffs a permissive appeal on a single question. Did the district court abuse its discretion when it denied plaintiffs' motion to reconsider the protective order? Mercy's position is that the court did not abuse its discretion, and there's been a lot of talk today about the initial protective order, and while Mercy believes that the focus should be on the reconsideration decision, we also understand that the reconsideration decision required the court to look back at its earlier protective order to determine whether or not it had correctly applied the law. Mercy believes that the court did correctly apply the law when it granted the protective order, and there's two main reasons for this. The first reason is that the plaintiffs delayed noticing the expert depositions after they received them. The plaintiffs received Dr. Schaefer's expert disclosures 88 days before the long-standing discovery deadline, and the plaintiffs received Mercy's expert disclosures 71 days before the discovery deadline. And instead of immediately telling the defense counsel that we want to get these depositions scheduled, they waited. And they did so for a very strategic reason. They didn't want to have to pay for the depositions in the event that mediation was successful. Mediation was not successful, as it often is not. And so right after mediation failed, they asked defense counsel if they could depose the experts. By then, it was simply too late. And I would like to...
Could they not have deposed even one expert during that time? Was there not even one expert available?
Well, Your Honor, I can speak to Mercy's experts. At the May 1st hearing on the original protective order, Steve Hippler, now Judge Hippler, represented to the court that he had attempted to get our 3 experts available for those dates in April that were within the discovery period that had been proposed by plaintiff's counsel, and our experts were unavailable. So there was an effort made. So that was the other point. We did try to schedule the expert depositions. However, many of the dates that were proposed by plaintiffs for depositions were beyond the May 4th deadline. In fact, they proposed 2 weeks of dates in May that were beyond the May 4th deadline when they initially proposed the dates. And so by the time they proposed the dates, it was simply too late. And the court considered the entire procedural history that led up to the May 1st decision when she reconsidered the decision later on.
You know, I understand that argument, but it seems to me that the plaintiffs extended Mr. Hippler quite the courtesy by extending the disclosure deadline for defense experts. What's the explanation for an absence of reciprocity in holding on to that May 4th date with both hands?
Well, Your Honor, I think that one of the factors that came into play there was the fact that the trial date had been pushed back significantly at considerable expense to both defendants. And so to then reopen discovery and let discovery continue past the May 4th deadline, when we had already had the trial pushed back about a year and a half, that was just
I'm
going to
talking
cause...
about a refusal to consider maybe a couple of extra weeks to slide in those defense experts.
I suppose they could have extended the discovery period, but I think that the question is whether or not, faced with the entire procedural history, the court abused its discretion when it entered the order. And so in light of the procedural history, in light of what happened at the April 11th hearing, the court entered the order 3 days before the discovery deadline. And our position is that that was not an abuse of discretion. Stand for any questions the court may have of me. Otherwise, I'm out of time.
Thank you. Very good argument for 3 minutes. How much time does the appellant have? Very well.
I'll try to be brief. The question, Justice Horton, is a good one. We extended them the professional courtesy of a 21-day extension. It seems a little disingenuous now to argue that that same courtesy couldn't have been applied at the end. That courtesy is often applied in the cases I'm involved in. Mr. Kwan talked about his historical representation. I also try these cases. This is the first case I've run into a problem where the attorneys try to use a discovery cutoff as a tactical advantage to foreclose discovery. I've never run into a case where they said midway through the discovery, we're not even going to put our experts up. And I keep coming back to the fact that there is nothing in the record upon which Mr. Kwan can make a representation of this court that even tried to get a single expert to provide their time. So there is no basis upon which this court could have made a determination that the plaintiffs were dilatory or had unreasonably delayed in this case, or that they were prejudiced in our request for depositions with that amount of time left. And until we get to that point, with all due respect to the defendants, I don't know then how you say that you have a reasonable basis under an abuse of discretion standard or a
What
reasonable
relief are you
excuse.
requesting?
We're requesting that this court send it back and allow us at a minimum to take those 8 expert witnesses. And I'm happy to address this.
Would your relief be just give us X number of days of depositions? Because that's what you were denied.
No, I think under the circumstance, Justice Eisman, it's entirely up to how this court wants to craft it. We have no trial date anymore. So this court can...
Trial been vacated?
It's been vacated completely. The last status conference we had with our new judges that when we find out what this court's ruling will be, we can revisit at that time.
You didn't ask to extend the deadline for discovery, so if you were denied the ability to exercise discovery during a specified period of time, why wouldn't that be just your relief? You get that many days to conduct discovery.
You can do that if you choose to do it. I don't think that relief would be in keeping with what this court has stated on numerous occasions.
Well, why not? I mean, you know, it seems to me that where there was no request to extend the discovery deadline, all you were denied was the ability to take any depositions that you could schedule during the remaining time.
Sure.
Why wouldn't the remedy then be to give you that amount of time to schedule depositions?
I'm not disputing that this court can make that remedy if it chooses to do so. It's whatever this court ultimately decides. In that regard, I guess I disagree with Mr. Kwan that you're limited in what you can do. I think this court has the power to do what it needs to do to make sure that this case goes to trial in a fair and reasonable way in keeping with what the court has decided is the rules involving discovery. We believe there was an abuse of discretion. I believe if you go to the transcript from the November 20th, 2012 hearing, and you look at Judge Hoff's rationale again on page 193 going into
Sir, your time is up.
194, you'll find that it's inappropriate. Thank you.
This matter is now under advisement. We will render decision.
It was my time. Well, I know how. And I know how old you are too.
Sure.
And you, sir. And you, Justice Jones, and the youngsters.